the questioning. Mr. Feith, I want to ask you about your role in Secretary Rumsfeld's December 2002 approval of techniques for use in interrogations at Guantanamo Bay. The cover memo from the Department of Defense Counsel Jim Haynes to Secretary Rumsfeld says, and I quote, "I've discussed this with the deputy, with Doug Feith and General Myers. I believe that all join in my recommendation," unquote. Did you undertake your own review of legality of the requested techniques? And if you didn't, whose legal advice did you rely upon?
We were relying on the General Counsel.
That is Mr.
Haynes.
Mr. Haynes. And had you seen the August 2002 OLC legal memo?
I don't think so. I don't remember when I first saw that. I've been doing so much work on the subject in recent years in doing research that I don't remember when I first saw that document.
But is it your recollection that that document would not have been influential in your deciding to accede to the Secretary's memo in December?
It's possible that I hadn't seen it at all.
But
I mean, I can't say that it's influential when I don't know that I saw it.
So you're saying it wasn't influential? Even if you had seen it, it wasn't influential? You don't remember seeing it enough?
I don't remember seeing it.
Okay, fine. In your written testimony, you state that you argued for application of Common Article 3's humane treatment requirement. Do you believe that the interrogation techniques to which you recommended Secretary Rumsfeld give blanket approval, stress positions, isolation, nudity, the use of dogs, qualify as humane? That would be in categories 2, qualify as humane treatment under Geneva?
I think it's important when we discuss this document. There's so much discussion of this this document on the Haynes memo on counter-resistance techniques. To understand the way it looked to us, I think it's extremely important to go back and look at the memo.
We have the memo.
I would encourage everybody to do that. I attached it as an attachment to my.
We all have the memo, sir.
Okay. In front of us. I attached it as part of my statement. When we looked at this statement, what it does is Southcom requested some additional techniques. I think there were 18 of them, and it put the techniques into 3 categories. And
excuse me, to cut to the chase, you said that categories 1 and 2 are okay.
Well, no, but let me just cutting to the chase, I think, leads to...
Hold on a second. Tell me if I'm wrong. You said that category, or if my summary is wrong. Categories 1 and 2 are okay, could be used. Category 3, while legal, is inadvisable, shouldn't be used.
I think that's largely correct. I think the question that you, Mr. Chairman, you seem to be getting at is shouldn't alarm bells have gone off when we saw this memo that
No, sir. The question is that you were acceding to a memo which said that the use of categories 1 and 2 were okay, legal and okay, and category 2 includes such things as the use of 28-hour interrogations, hooding...
20-hour.
What?
You said...
Oh, 20. It looks like 28 here. The 20-hour... I don't know the great difference. The use of 20-hour interrogations, hooding, removal of clothing, use of detainee individual phobias such as fear of dogs to induce stress. Wouldn't that be the normal definition of anyone's concept of torture? Hadn't it always been?
I don't believe so, but especially not...
I'm sorry, let me rephrase that. It shouldn't be torture. Are those humane treatments as that we should apply?
Okay. The way one could... I imagine one could apply these things in an inhumane fashion, or one could apply them in a humane fashion. The general guidance...
How could you force someone to be naked and undergo a 20-hour interrogation?
It doesn't say naked.
Removal of clothing. Removal of clothing doesn't mean naked?
Removal of clothing is different from naked.
Really?
It talks about removing of comfort item and of clothing that would make people... The idea was to induce stress, they talked about, but one could induce... In our police stations around America every day, American citizens are subjected to stress as part of interrogations. It can be done in an inhumane way. It could be done in a humane way. The general guidance...
Wait. Are you saying... I find it hard to believe, hard to imagine, I should say, how you can have, how someone can have a hood placed over his head, albeit not restricting his breathing, undergo a 20-hour interrogation while having his clothing having been removed and using his fear of dogs or other
Mr. Chairman, point of order.
And how that could be considered humane.
Mr. Chairman, point of order.
The gentleman will state his point of order.
The chairman is ignoring the 5-minute rule. Under Rule 11, Clause 2J, it requires that questioning the witnesses occur under the 5-minute rule until each member has had an opportunity to question the witnesses. When you allow members to take more than 5 minutes, it's a violation of the rules, and it potentially derives...
You're 5 seconds over the 5-minute rule. You're 5 seconds over the 5-minute rule.
I ask that the chairman be granted an additional minute.
Without objection, the chairman is granted an additional minute so Professor Feith can finish answering these questions.
When one looks at this memo, what one sees is people were saying in Southcom that the interrogations under the field manual were not working with respect to some particularly important and difficult detainees. And they said, we would like to go beyond the field manual. Our understanding was, at the policy level, that there were legal limits. The limits, for example, set by Geneva to the extent they were applicable. The limits set by the torture statute. We understood there were important legal limits.
I understand the circumstances in which you're trying to go.
I would really request...
We are proceeding under Mr. King's strict time instructions, so I have to get the question in. So your testimony is that the use of these techniques meet the humane treatment standards, and that, let me ask you last, if Common Article 3 of the Geneva Convention is applied, would these techniques be allowed?
Mr. Chairman, point of order.
I'll recognize your point of order when the gentleman has finished his answer to that question.
Mr. Chairman, I would really like to try to answer this in a way that gives the picture that explains how we read this memo.
And if Mr. King will not object,
Mr. Chairman, yes,
we'll have an additional minutes to answer.
I object. Mr. Chairman, I think the minority, if I may speak, the minority fully intends and wants questions to be answered fully. We're not trying to cut off answers, only follow-up questions after time has expired. If the chair would observe that, we certainly want full answers by the witnesses.
I move that the chairman be given an additional minute.
Without objection, Mr. Feith.
Mr. Chairman, the way I looked at this memo was there were important legal lines that everybody understood cannot be crossed. Whatever was the law of the United States, the Geneva Convention is part of the law of the United States, the torture statute is part of the law of the United States, the torture treaty. Whatever the legal limits were, they had to be respected. The president, furthermore, before this point, the president furthermore said all detainees must get humane treatment.
Professor, you have not answered the question. The question is, if Common Article 3 of the Geneva Convention applied, would these techniques be allowed?
It depends how they are. It depends how they're used. They could be used in a way that violated the convention. They could be used in a way that's consistent with the convention. There was guidance given, and all of this was under that guidance.
So they are not per se.
Everything had to be done
regular order,
lawful and humane. And one of the things that I would urge you to do, if people actually read the October 11th memo, you will see that it shows a great care. It shows concern for humane treatment. It shows concern for the kind of issues that you raised, Mr. Chairman, that if they were used in combination, there could be a problem.
In the second round of questioning, perhaps you could show which words in that memo show that. On that,